Hi everyone, my name is Rachel Seelig. I'm a staff attorney in the Disability Law Project at Vermont Legal Aid, and today we will be talking about how to file an administrative complaint for your child with a disability. We're going to start by going over the different options for dispute resolution, and then we'll move on to reviewing how to use the Agency of Education's administrative complaint form, and then going over the complaint processing procedure that the Agency of Education uses when they are reviewing a complaint that has been filed. And then last, and I think probably most important for most people, we'll talk about how to try and resolve a complaint. Most complaints are able to be resolved without having to go through the whole investigation process. So the regulations for special education, and these apply for all children who are eligible for special education, those who are 0 to 3 and in early intervention, as well as older children 3 to 21 who are in either EEE or in a regular school system. So the first option for mediation, for dispute resolution, is what's called mediation, and I'll go over what that means a little bit more in a second. We're going to be focusing today on administrative complaints, where we're asking the Agency of Education to perform an investigation. There's also an option for a due process hearing where a judge actually makes a decision about who wins and who loses a case where you're complaining about what your school district or your early intervention program is or is not doing. These are not necessarily things you have to do in a certain order. You can certainly start by trying to solve your problem with mediation, be unsuccessful, and go on to an administrative complaint, not get the finding you want, and file due process. That's definitely an option. You can also, though, start by trying to mediate a dispute and then go to a due process hearing. Or you could start by filing an administrative complaint and then agree to mediate to try and resolve that complaint. And we see that happen quite a lot. Unfortunately, and you can also do a due process and then end up mediating to resolve the due process. And we also see that happen a lot. Very few cases in Vermont that are filed as due process complaints end up actually having a judge make a decision because people end up being able to work things out. What you cannot do, though, is file a due process, lose your due process case before the judge, and then file an administrative complaint about the exact same issues. That is not allowed under the rules. So mediation, it's important to understand because, as I said, a lot of administrative complaints do end up resolving because the parties end up mediating. So what happens with mediation is you and folks from your school district or your early intervention provider get together with a neutral third person whose job is to try and help you figure out how to solve the problem, to come to a compromise. Mediation is free. It's no cost to the parent. The Agency of Ed keeps a list of mediators who have experience doing mediation on special education issues. It's voluntary in that if someone offers to mediate a dispute with you, you can say no, you don't have to do it. But you can also agree to mediate, figure out that you're not going to get what you want when you're sitting there in the mediation with that neutral person, and walk away. And the reason you can walk away is it is not a mediator's job to decide that your side wins or the other side wins, to decide who is making the better legal arguments. That's not what mediation is about. It really is trying to find a compromise and having someone who doesn't have a stake in the issue help work things out. Mediation is confidential, and if you can come to agreement, that is binding on both parties. And so if your school district or your early intervention provider doesn't follow through with what they say they'll do in your mediation agreement, you can take action to enforce that. So that's mediation. What we're actually here to talk about today are administrative complaints. An administrative complaint is basically a request that you have the Agency of Education investigate a violation of the special ed law, the IDEA, that you think your school district or your early intervention agency or provider has made a violation of that law. If you think it's actually the Agency of Education or the Agency of Human Services who's violated the special education law, you should call Vermont Legal Aid for advice about how to do that kind of an administrative complaint, because it is a little trickier when it's the supervising agency that you think is a problem. An administrative complaint will likely lead to an investigation, and the Agency of Education will decide how it conducts that investigation. So it might include looking at documents that you and your school district or early intervention provider have submitted. It might include meetings. It might include an on-site visit to the location. One of the advantages to administrative complaint is you do get a written decision in 60 days. So it's a fairly short timeline to know whether what you think is a violation is actually going to be treated as a violation by the Agency of Education, and then if it is treated as a violation, what they're going to do about it. In order to file an administrative complaint, you have to provide the Agency of Education with certain information. You don't have to use their form. The Agency of Education has put together a form for administrative complaints. It's not a required form, but I do recommend using it. The main reason I recommend using it is that way you make sure that all of the things that you have to provide to the agency for them to actually investigate are included, because the form makes sure that the things that they have to have are lines for you to fill in. So those required pieces of information, if you really don't like forms, are a statement that the special education law was violated, your facts to support that statement, your signature, and your contact information. And if you're saying that these violations affected a specific child, you also have to provide information about the child, their name, their address, their age, their school, how to get a hold of them if the child is homeless, what the child's problem is and what the supporting facts are for that, and what you think could solve the problem, how to resolve it. So we are going to use a hypothetical, a pretend child named June, who is 5 years old and in kindergarten, as an example as we walk through how to use this form and how to think about these complaints. So June is now in kindergarten, but last year when she was in pre-K, her mom thought she might have autism or a learning disability. She wasn't really sure what she thought was going on, but she knew that something was going on, because June was having a hard time staying in the classroom, even with extra help that the school was giving her. So June's mom had asked the teacher to evaluate her for special education, but it took a couple months before the school even scheduled an evaluation and planning team meeting, which is the first meeting to figure out, are we going to evaluate this child for special education? This could also happen for younger kids, where you think that something is wrong and you call the Agency of Human Services, or you call your early intervention or children's integrated services provider, and then nothing happens. That would be the same kind of scenario here. But in June's case, she did end up getting an evaluation. It took a long time. And she was diagnosed with autism and found eligible for an IEP. And the IEP is the document for kids who are in school. For the younger kids, for the 0 to 3, it's called a one plan, or an IFSP is the other acronym there. The team that met also agreed she was going to need ABA therapy, which is a kind of therapy for children with autism, and that she needed that as part of her IEP. But 8 months later, there was still no ABA in place. And so that was certainly a problem for June's mom. And so we're going to use this as our example to go through how to fill out the form. So when you look at the agency's form, the first thing you'll see is a cover page, and it gives some important information. One thing is you can only complain about something that has happened in the last 1 year. That is different than if you file a due process complaint where you're going to go before a hearing officer or a judge. In those cases, you can look back 2 years from the date that the violation occurred, or you should have known the violation occurred. So if something happened a longer time ago and things have been okay since, an administrative complaint may not be the right way for you to go. The cover page will also tell you you have to sign your complaint. If you don't sign your complaint, the Agency of Education won't investigate. Now, ideally, they will send it back to you to sign it if you just forgot, but that is a requirement. And you do need to answer all the questions that have an asterisk. Those are the questions that make sure you have provided the necessary information. Another rule is that you need to send a copy both to the agency of education and to the school district or early intervention provider. So it's not a secret when you file a complaint. The school district or the provider that you're having a problem with is going to know that you're asking for an investigation. If you're filing a complaint about early intervention services, you should send your complaint to the agency of education, to the provider, and to the Child Development Division at the Agency of Human Services. And the address for them is included on the complaint form. It's important to be thorough, and the instructions will say this as well, because if you don't include something that you think went wrong, it won't be investigated. And that makes sense. If you don't let the agency know that there was a problem with something, there's no way for them to guess that there was a problem with something. And the cover page will also tell you you can attach documents that you think would be helpful for the investigator. And that will tend to be at least the child's IEP or their one plan if they're very young. Their evaluation will probably be included if there's been an evaluation. Other things that might be helpful will be letters from outside providers like their doctor, copies of emails or text messages. And when we get into some of the kinds of complaints that you can file, we'll also look at what documents might make sense in different cases. So a lot of this form is pretty easy to fill out, and so we're going to go through these next couple slides fairly quickly. The first part is asking for the complainant information, and this is because the complainant is usually the parent, but it can be another adult. So it could be a grandparent, it could be someone else who knows the child and thinks that something is going wrong that needs to be investigated. But in this case, we're going to use June's fake mom, Jane, as our example. Jane does not work for an organization, so she doesn't have to include anything there. But we've got an address and a phone number and an email address and her relationship to June, which is she's the mom. Next, we have student information. And so here we get June's name, June's address, her date of birth. She's in kindergarten. That means no, she has not received a diploma. That question becomes important because once a child has graduated from high school, their ability to file complaints about things changes. The school of attendance. If your child is in an early intervention program, you should write down that early intervention program rather than the public school in your area. The district of residence and the parent's name. And then if the child isn't living with the parent's address and phone number would also be included down here. So again, this is just, basic demographic information that the agency needs to investigate. The next question that they have is, what disability category does the child have? And sometimes you know this, right? Sometimes you're filing an administrative complaint and your child has been getting services for a long time and you know what their disability is. Sometimes you're filing an administrative complaint because you've been trying to find out what their disability is and no one will evaluate them. And so if you're not 100% sure what category it is, that's okay. Check off the ones you think might apply. So in June's case, her mom thought maybe it was autism, maybe it was specific learning disability. And so she checks off both of those boxes. She might have also thought it was a developmental delay, and she could check that box too. So it's okay to over-check boxes here. That's not a problem. The next question is, do you have an attorney or advocate? And if you do, what's their contact information? And what I would say is usually if you have an attorney or advocate, they're going to be filling out this form for you or with you. And so they'll be able to provide this information. The next question asks if there is a complaint history. If these problems that you're complaining about have been complained about before in an administrative complaint or in a due process complaint or in a mediation. And they also want to know if there is a current due process complaint or another administrative complaint or another mediation going on right now. And the reason for that is, again, if you've already lost a due process complaint on the same issues, they're not going to conduct a new investigation. And if you've got a pending due process complaint on the same issues, they're going to let that due process complaint go on. They're not going to stop that complaint process to start doing this investigation. So if you think you might need both an investigation report and a hearing, you want to start with an administrative complaint. But in this case, June's family has not done any of those things already, and there's nothing else that's already gone on, so she checks the no boxes. The next question is about mediation. And as I said before, a lot of these cases end up resolving with mediation. You do not have to agree to mediate them. So some people will check the no box here, and some people will check the I would like to receive more information on mediation box. And the reason for that is you don't decide, yes, I'm 100% going to mediate, but I've given you a little bit of information about mediation today, and you might want more before you make that decision. So it gives you some time to think about that. Next, you need to confirm that you have sent your copy to your school district, or if it's an early intervention, if a child between 0 to 3, to the early intervention provider. You can mail it or you can hand deliver it. Either of those is okay. But the state needs to know when you did that and who you sent it to. So in our case, June's mom mailed it today to the special ed director at the school. Now, if June was still in an early intervention program, this would not have gone to her school district. This would have gone to her early intervention provider. Next, we finally get to the meat of an administrative complaint. This is where the agency wants to know, what are the issues? Please describe them. Now, the information on this page, this description of issues, the directions talk about violation of a requirement of Part B of the IDEA, which is the part for children 3 through 21. But you can also use this same form for a violation of Part C, which is the part that's for children 0 to 3. So the directions here are not the best, but I promise you can use this complaint for both. And even though I said before I do recommend using the form, for this question, I usually put in, please see attached. And the reason for that is, unless you really are only complaining about one thing, there's not enough lines on the form itself to necessarily explain all of your problems. So you write, please see attached, and then you write out all of the problems and all of the facts on a separate piece of paper, and then you include that with your complaint form. So that brings us to the very important question of what issues do you put into an administrative complaint? Well, the rules say that you can file an administrative complaint about any violation of Part B or Part C. So for anyone 0 to 21, that you can file that in an administrative complaint. So that would include both procedural issues, process problems, not getting things done in a timely manner, not having meetings when they're asked for, not having meetings when the parent can attend the meetings. Those are all process problems. Or it can be substantive problems. They are not providing the services that they need to provide for my child to get their free and appropriate public education, which is the requirement for special education. We do tend to find that the administrative complaint process works a little better when your problems are mostly procedural. But you are absolutely allowed to make a complaint about substantive problems too, because again, the rule says any violation. So one of the ways to identify issues is to go to that Notice of Procedural Safeguards book, because that lays out what your rights are. And so if your rights have been violated, you can write those down. Those are some of the things that maybe have been problems. For us at Vermont Legal Aid, and I think this is also true for VFN, we see problems with, for the most part, evaluation and eligibility, sometimes with problems with the IEP team, often discipline issues. And then we sometimes see other issues too, problems with getting assistive technology in a timely way, deciding whether the student is eligible for extended school year or not, making sure that there's an adequate transition plan that meets all the rules for transition. That's really for older kids who are 14 and up and starting to think about when they finish high school what's going to happen next. Transportation problems, confidentiality of records. These are all possible issues that could be brought up in an administrative complaint. We're going to get back to June's example, though, to identify a couple to kind of give you some examples. The way that we generally will write a complaint is to make sure that there are at least 3 components for each of the things you think the school district or the early intervention program has done wrong. First, you're going to explain what you asked for and why. In other words, what you think should have happened. Then you're going to explain what the school district did in response. And finally, why you think that response was wrong and what the consequences have been for that student. So if you include those facts, that should lay out the conduct that you think was wrong by the school that you want investigated. If you happen to love rule books and you want to go through the special education rules and find the rule numbers, you can include those. But that's not a requirement for filing a complaint. It can be helpful to include. So again, we had 2 problems for June. The first was that it took more than 2 months just to schedule a planning meeting to evaluate her. And then the second problem was 8 months after she got her IEP, one of the services still has not been provided at all. So the first problem, the failure to start the evaluation, her mom explains first, she asked at a parent-teacher conference in February to get her evaluated because she was behind in class and the teacher said it was hard to keep her in the classroom. And at that meeting, this parent reports, the teacher said she would talk to special ed to get that to happen. Mom then explains she came into school every morning in February and March to drop the child off. Several times she asked if there was anything she needed to sign to get things started, and the teacher was usually busy, so she emailed her. And finally, she got a meeting notice on April 12th, scheduling a meeting for April 18th. And the problem with that was, in Mom's view, she thinks the school is wrong to wait so long to set a meeting to talk about evaluating June. And she didn't therefore get the services that she needs for that very long period of time. So in this 3-sentence explanation, June's mom has explained what she asked for, what she tried to do to solve the problem on her own, and what the consequences were. And so that tells the Agency of Education this was a failure to start the process. Now, these same facts would probably also support that the school district didn't do what's called child find, where they have to identify and evaluate children where they think that they might have a disability and might need special education. Because you have to lay out all of the things that you think the school district did wrong, even though these same facts support that, if you also think there was a child find violation, you should also lay that out. Because hopefully the Agency of Education would read this and see those are both problems, but you're better safe if you want them to investigate both to lay them out separately. For June's second problem, failure to timely implement the IEP, her mom writes, the IEP team put in the student needs section that June needs ABA therapy. It was also written on the services page, and so it should have been provided promptly. At the meeting, the special educator said it might take a little time to assign someone. They didn't have anyone already there to do the ABA, but they still haven't hired anyone or assigned anyone to June. And mom feels this is wrong because the IEP says she needs the ABA and she isn't getting any at all, so she isn't making any progress. So again, mom has laid out here what she asked for, what the team agreed on, what has been done or not done since they still haven't hired anyone, and what the consequence has been for June, that she hasn't made progress. And that might very well mean she's not getting her free and appropriate public education. So next, the Agency of Education wants to know, what have you tried already? And June's mom explains some of that, but details are always good. So if she can go back and remember when did she ask and how did she ask for the evaluation? Was it verbally? Was it by email? Was it to the teacher? Was it to the principal? Was it to the superintendent? That's really helpful information to be able to provide. If it was just verbally, before you file an administrative complaint, you should probably also put it in writing. So that then you can show, I did also try this in writing, and it still didn't work. For the problem of starting the ABA therapy, maybe she attended 6 different meetings with the team and asked, what are they doing to get someone set up? When will it start? What are you going to do in the meantime? She also says she asked for mediation, but the school didn't want to mediate at that point. So explaining to the Agency of Education that you've really done your due diligence, you've tried to solve the problem at the lowest possible level with the IEP team or with mediation, and that hasn't worked out, that helps the agency know this is not someone who's kind of jumping the gun and hasn't really tried to solve the problem themselves. And that's good for the investigator to know in terms of how they're going to deal with the school district or the early intervention provider. So last, the agency needs to know, how do you think the problem can be solved? Now, if June's mom had filed her administrative complaint back in March of last year when she'd been asking for an evaluation, the problem maybe could have been solved by scheduling a meeting and doing the evaluation really quickly. But the evaluation's happened now, and so June's mom may now be more concerned about this happening to other kids. So she may want the school district to change its policies so that this doesn't happen for other children. For the ABA, she may ask that the Agency of Education require the school district to contract with a private ABA provider, since they haven't been able to provide the services themselves. Or she might ask for what's called compensatory education. That is asking the provider to pay for a private tutoring or a social skills group or something else that goes above and beyond what the student needs to receive their free and appropriate public education to make up for not having provided the services when they should have been provided in the first place. The rules do also allow you to ask for financial compensation. So if you've put money out for services, you maybe can ask for that to be reimbursed. And then the last piece of the last page is your signature. And again, you have to sign the administrative complaint for it to be valid. Once you've signed it, you send it into the Agency of Education. This is their current address, but they do plan to move at some point in 2019, and I don't know exactly when. But I will expect them to update the form, so it'll be whatever the address is on the form. So don't use this webinar for the address, just use it for how to fill out the form. It can be faxed or it can be emailed. And again, in addition to mailing it, faxing it, or emailing it to the Agency of Education, you have to send a copy to the school district or the early intervention provider. And if it's for an early intervention child, you need to send it also to the Agency of Human Services, and that address is on the form. The next question that we often get is, well, what do I attach? What else should I provide? Is it just the form? Is it more? Usually it's not going to be just the form. Usually if you have some documents, that is helpful for the evaluator, for the investigator, I mean. So for the failure to evaluate claim, you want to show that you made the requests that you're saying you made, which is why just making verbal requests can be a problem because you don't have a record of those necessarily. But if you sent an email to the teacher or the principal or the director of student services or the early intervention provider and you didn't get a response, you can print out those emails and send those in. If you did get a response and the school district or the early intervention agency said, we're just not going to evaluate this kid, then you can send in that email or that letter, however they wrote back to you, to let you know. And if you think that there's other information that the school district or the provider had that might have supported that they needed to do what you're asking them to do, you can include that too. So that might look like report cards with really low grades, or a diagnosis of ADHD from your doctor's office, or lots of disciplinary problems, or You may have gotten a form because your child was restrained or secluded at school. That very well may be an indication that they need to look at, does this child have a disability? And so you can include those kinds of things with your complaint form and then your list of what were the problems, what were the issues. For the failure to timely implement the IEP, you want to show that the team did actually agree to the services you think they agreed to. So that probably means sending in the IEP or the one plan if it's for a very young child. And any minutes from IEP meetings, from team meetings about what they were doing to try and get services started or not doing. And then any other information you have to show that services that you asked for had not started. And those might very well be text messages with a case manager. You can take a picture of those on your phone, a screenshot, and email those to yourself and print them out. Whatever you attach, make sure it's not your only copy, because when you send it in to the Agency of Education, they will keep it. So you want to make sure you make copies to send in, whether you send it by mail or by fax or electronically. You want to make sure you also have a copy for yourself. So your work at that point is mostly done. At that point, it's now on the agency to step up and do something. When they get the complaint, they have an administrative complaint procedure. So the first thing that they do when they get it is they date stamp it on the day that they get it, and then they send it to the legal office at the Agency of Education. An attorney is assigned, and the attorney's first job is to make sure that your school district or your early intervention provider got a copy. So make sure you send that copy. And their second job is to make sure that you know what your parental rights and procedural safeguards are. So they mail that out to you, even if you've already gotten it from your IEP team or from your one plan team. Next, the agency attorney reviews your complaint. They need to make sure that your complaints are really about a violation of the special education law and not about something else. They need to make sure that all of the information that you have to include has been included. And if you use the form, that will be taken care of. And then they will pair up with someone at the Agency of Education who has expertise in the issues raised. So if you're bringing up a problem with evaluations, they'll pull in a staff who actually knows about evaluations. If you're complaining about a problem with transition services, they'll pull in staff who actually knows about transition. So it's not just an attorney by themselves. It's going to be an attorney and someone who knows that subject pretty well. And then they have to give the school district 15 days to respond to what you've raised in the complaint, and to give you 15 days to add new information if you think you maybe left something out. And you can either do that in writing or by phone. So if you really feel like you need to talk with the investigator, if you're not sure if you wrote things down very well, you can do that in those first 15 days. The investigation has 60 days for completion, and that's all the way to completion. That means that they have written a report and they've run it through the chain of command at the Agency of Education, and they're mailing it out to you and to the school district or the early intervention provider. The only time that those 60 days will be extended is if you agree to mediation, because sometimes it takes a little time to schedule a mediation, or if there are some exceptional circumstances. And these timelines are calendar days, not school days. So that's something to keep in mind. When you're counting school days, things end up being a lot longer because you're not in school on the weekends or vacations or in services or that sort of thing. A lot of times, a school district, once they know you filed an administrative complaint, will offer to mediate with you to try and resolve it rather than have to go through a whole investigation. Mediation often makes sense if you've tried to meet with the school and it just hasn't worked out, or if your primary issue is solving this child's specific problems, not something you think is maybe a problem across the whole school district or across the whole early intervention program. And the other reason mediation might make sense is if there's a problem that's still happening today or it's coming up. So a child who was told you're going to get extended school year and then the extended school year is going to be taken away but it's not summer yet, so you still have some time to maybe get that put into place. That would be an example of something where it's ongoing or it's coming up, and so maybe you can solve it in mediation rather than having to do an investigation. If you've already tried to mediate, though, or if you've solved the child's individual problems but you're worried about the system, mediation may not be as effective because you can't really solve the systemic problem on behalf of everyone as easily. If you don't mediate, or if you try to mediate but then you walk away because you couldn't get what you want, the investigation team moves forward with their investigation. And again, they do get to choose how they will investigate. So it might just be that they review documents. It might be that they meet with you or with folks from the school district or both. They're allowed to hold a hearing. I haven't seen that happen, but it is allowed under the rules. And they are also allowed to do on-site investigations where they come and observe at the school and meet with people in person. They can do any one of these things or any combination of these things. But it is the agency's decision which of these things they will do, not yours as the person who's filing a complaint. So you can't require them to go to your child's school. You can encourage it, but if they don't do it, that's not something they've done wrong. The investigation team will then consider, first of all, were there violations? And if they were, how big were they? If this was a one-off thing, a mistake, they might just give what's called technical assistance to the school district or the early intervention provider. So they might say, hey, you guys, you made a mistake. Here's how you can fix it, and then move on. If it's more of a systemic issue, which might mean that it's affecting more than one student, or might mean that one student has experienced multiple violations of the special ed rules, the investigation team could recommend, and their report could require, a corrective action plan, where the school district is going to have kind of a timeline to take certain actions, maybe change policies or do some training so that those problems don't continue to happen in the future. And they write their report. And the report goes up a chain of command. So first it goes to the Director of Special Education for the state, and then it goes up to the state, the Agency of Education Secretary, who has the final sign-off on that report. And then it gets mailed out to both the complainant and to the school district or early intervention provider. Once that complaint process is over, you know whether it's either favorable to you or not favorable to you. If the report found that there were violations and corrective actions needed to be taken, you should follow up with your school to make sure that those actions were taken. And if they're not taken, call the investigators, ask them to step in and make sure that what is supposed to happen happens. If your complaint is not favorable to you, that is, you thought that there were violations of the rules, the investigators did not find the things that had happened to be violations of the rules, you can't appeal the report, but you could still file a due process complaint and have a hearing officer, a judge, look at those same issues again as if they'd never been investigated. So you do have another step that you can take if you feel like you really need to. So that's the kind of quick and dirty of the administrative complaint process. We went through that fairly quickly. I see I do have a couple of questions here. So let me see if I can work through those. And if anyone else has questions, you can use the question box in this webinar platform, and happy to take a look at those too. So the first question I see here is, how many administrative complaints does the Agency of Education receive in a typical year? So I have some information from the Center for Appropriate Dispute Resolution in Education. And in 2016-2017, 17 state complaints, administrative complaints, were filed in Vermont. 9 of those ended up being either withdrawn or dismissed. 1 was still pending when this report was put out, and 7 were issued with reports within 60 days. Just to compare that, in 2016-2017, 9 cases were filed for due process. All of those ended up being withdrawn or dismissed or resolved without a hearing. So that doesn't necessarily mean there's something wrong with the process. Oftentimes, if you filed either a due process complaint or an administrative complaint, it brings the school district or the early intervention provider to the table so that you can work things out. So that can be really helpful. I see another question here. Can your personal notes from meetings be submitted as supporting documentation? That's a really good question. Yes, they can. I would also include whatever the official meeting minutes were, so that the Agency of Education can see if there's a difference between kind of what the person taking the meeting minutes perceived to be going on and what your notes from the meetings were. That way you're showing that you're trying to be as fair as you can with the different perspectives about what was happening. It's a really good question. Thank you for that. The next question I see here is, my child isn't receiving the services in their IEP. I'm afraid that if I file an administrative complaint that it will make things worse. What are your thoughts? This is a really good question and an important question. It's a legitimate concern, because if you're already having some tension with your IEP team or your IEP case manager, and then you go ahead and file a complaint and so they're being investigated, it's likely that just because of human beings, tension is going to go up. But a school district is not allowed to retaliate against you because you filed an administrative complaint. That's one of your procedural safeguards. It's one of your rights under the IDEA. And if you do experience retaliation, you can add that to your complaint so that that can be investigated as well. Okay, we have another question popping up here. Let me take a look at this one. So this person says, we're having procedural problems with our IEP process. The school is deciding placement before there's even an IEP meeting and before any needs or goals have been discussed or established. I understand this to be the wrong way to develop the IEP, and it is definitely calling into question the validity of that placement. Is this something that can be addressed through an administrative complaint? So my goal is always to try and resolve things at the lowest possible level. So if you can bring it up with the team and say, hey, you're coming in with an IEP that's already written and decisions are already made, and I'm not really getting my input here, and I have a right to do input. If you can change the team's mind so that you're actually having a conversation, great. If you've tried that already and you haven't seen any change, yes, that IEP process in terms of the right for parents to have input and for meeting decisions about placement have to be made by the IEP team. So they can't be made before a meeting. Those are certainly things that you could file an administrative complaint about and ask for an investigation. And again, it might end up being an investigation. You might end up being able to mediate and resolve those problems with placement and process through mediation instead. Very good question. Next question I have here is, I know other parents whose children have an IEP, and we all have the same complaint about the need for an extended school year or summer service, which the school says they don't offer. Could we file one administrative complaint as a group? If you've got a group of people who are all experiencing the same problem, that is the kind of thing that I would actually recommend you call Vermont Family Network or Vermont Legal Aid about. Yes, it is possible to file a systemic administrative complaint. It's a little bit more complicated though, and so it probably makes sense to at least consult with an advocate or an attorney, even if you just get some information from them and decide to go ahead and do it as a group of parents. The next question we have here is, what should I do if the school doesn't follow through on the findings from my administrative complaint? I've called the investigation, but they don't call back. That can be a little tricky. If the school hasn't followed through and the investigator isn't calling back, you can kind of move up the ladder at the Agency of Education and talk to the people who are higher up, whether that's the Director of Special Education or all the way up to the Agency of Education Secretary. But if you're having that kind of they won't call back problem, I would also suggest that's another good time to call Vermont Legal Aid or Vermont Family Network, because we have some pre-existing relationships with folks at the agency, and we can try and use those to solve some of those kind of missing a call and callback problems. I would also say a lot of times I hear, oh, someone never called me back. And it turns out they did call back, but the call was screened and they didn't leave a message because it was a phone number that someone didn't recognize. Or they sent an email, but it went into the spam folder. So I try not to assume the worst, and there may be some other kind of communication challenges going on there. Oh, okay, we have another one here. Should you file an administrative complaint if you've already agreed to go through mediation? Can the finding of the administrative complaint be considered in a due process hearing? So if you are already in mediation currently, you're gonna have to check the yes box on that question about is there something currently pending, and the Agency of Education will hold the complaint. They won't start the investigation until that they know if that mediation is resolved or not. And then in terms of the second question, can the finding of the administrative complaint be considered in a due process hearing? That's complicated because it has to do with rules of evidence. But if you are going to file a due process complaint, maybe because the administrative complaint has not been followed through on, it's likely that you would be able to get that in and have the hearing officer consider it. It depends on the circumstances, and it depends on whether you want the full report in or if there are certain parts of it that you need to get in. Okay. Next question. I'm glad we have so many questions today, especially because we got through things a little more quickly than I had expected. How can I find out if my child is receiving all of their related services? He is nonverbal and can't tell me. I've heard from other parents that I should ask for the Medicaid billing reports. What are your thoughts? So this is veering a little bit away from administrative complaints, but it's a good question. So yes, you can ask for the Medicaid billing reports for your child. Those would be considered part of your child's educational record, and so you do have the right to review those. I would also say if you are concerned about their related services, you can ask for an IEP team meeting to be held and specifically ask for the providers of those related services to attend to give you an in-person update on what they've been working on and what progress they're seeing and whether they think the goals need to change. So that can be another good way of gaining information from those providers without necessarily always looking to kind of maybe seem like you're very adverse to the school. As I'm answering that question, I see that someone has kind of maybe a follow-up question to that. What if you've declined to provide consent to bill Medicaid? If you're not allowing your school district to bill Medicaid, there will not be any Medicaid billing records for you to review. So you can also ask for other records because you have the right to access your child's records. Most related service providers are going to be keeping records of the work that they're doing, either direct service or consultation with your child. And so you can ask for copies of those as well to see what their notes are. And that would be another way of kind of getting a sense of what they're working on. Okay. I have another question here. I never heard back from the agency or my school after I filed an admin complaint. What should I do? So this kind of goes back to what I said before is, are you 100% sure you didn't hear back from them? And if you never received a copy of the parental rights, the safeguard booklet that the agency has to send out when they receive a complaint, the first thing I would recommend is calling the Agency of Education and saying, I mailed it on this date. I haven't received anything since then. Have you received it? If they haven't received it, then resend it. If you can't get a hold of anyone, Then I recommend calling Vermont Family Network or Vermont Legal Aid so that, again, we can try and use our contacts at the Agency of Education to find out kind of what's going on. Again, the agency has 60 days to complete their investigation and write their report, and they don't have to be talking to you the whole time. So you might have gotten a letter with, you have the right to supplement this within 15 days, and here are your procedural rights. And that's kind of the communication you're going to get from them potentially for the next 60 days. They don't have to meet with you. They don't have to talk to you on the phone. So it may be that they are actually investigating. Okay. Can we contact Vermont Legal Aid with additional questions? Was there anyone at the Agency of Education who can answer questions? So yes, you can absolutely call Vermont Legal Aid with questions. Our toll-free hotline is on the slide that you're looking at here, 1-800-889-2047. Some questions might be able to be answered with the information that's on our website, vermontlawhelp.org, with a special page on education, and there are special answers on special education issues there too. Is there anyone at the Agency of Education who can answer questions? Yes, absolutely. There are folks there, and so you can call the Agency of Education's phone number with questions as well. And that number is on the administrative complaint form and on their website. And I'm sorry, it's not on the slide right here, but that is publicly available. Got another question. Do all admin complaints include an interview of the person who filed the complaint? I kind of answered that one already. Unfortunately, no, that is not a requirement of the investigation process. The investigators do have flexibility to decide how they're going to investigate. And in some cases, reviewing documents may be enough for them to figure out if there's a problem. In other cases, they may feel like they really need to interview the complainant to find out more, or to kind of get feedback after they've heard from the school district or the early intervention provider you're complaining about. And then the last question is, how does Vermont Legal Aid help parents with special education issues? So at Vermont Legal Aid, we have our Disability Law Project. Our Disability Law Project represents children with disabilities. So we often work with parents because their children either can't give direction to a lawyer or don't really understand what's going on. And so we do work with parents because the parents are giving direction for their child. Our Disability Law Project works on special education issues. It really depends on the issue whether we can take on what we call full representation of the client or not. But we give a lot of counsel and advice to people on how to advocate for themselves, even if it is not a case where we can represent you in a due process case. And we tend to focus on kids who are out of school, who have been inappropriately restrained or secluded or disciplined, or children who are in alternative settings.
So I'd like to thank everyone for joining us for our webinar today. I encourage you to visit our website at vermontfamilynetwork.org, where you'll find a lot of hopefully helpful resources. We have our upcoming webinars listed, and there's full information about our conference coming up in April. We're going to save this webinar on our website, but also on the Vermont Family Network YouTube channel. Of course, if you'd like to talk with someone here at VFN, we're all parents ourselves, we'd love to hear from you. Our toll-free number is 1-800-800-4005. Have a good day. Thank you.